Hey everyone, Chris here. Thanks for checking out the podcast. If you're enjoying it and learning something along with us, please consider becoming a supporting patron at patreon.com/ateachershistory. Or you could leave a rating and review on iTunes. It would be a huge help. If you'd like to raise your hand and participate along with us, you can find us on Facebook, Twitter, @ateachersfist, or shoot me an email, chris@ateachershistory.com. All right, let's get on to the next episode. Hello, welcome into A Teacher's History of the United States. Thanks so much for joining us again today.
Did you know that at around the time of the Marbury case, the same man was simultaneously the Secretary of State and the Chief Justice of the Supreme Court?
Did you know that after his inauguration and entering office, Thomas Jefferson knowingly refused to give 4 different commissions to federal justices that John Adams had signed and Congress had approved prior to the transition?
And did you know that the Marbury case was the first instance of judicial review being applied to a federal statute, and that it wouldn't again be implemented in the federal context for another 50 years?
Did you know all of this? Maybe, maybe not. Get your notebooks out because today we will cover that and more in episode 93. Extra credit. Marbury versus Madison. All right, everyone. Welcome into episode 93, extra credit episode. And as you could probably tell from the voice at the intro, Bill is on this episode with me. Bill, welcome back to the pod, my friend.
I have returned.
Yeah. That's great. Okay. That's good. I'm glad you've returned.
We'll get to that quote later.
Okay. Yeah, that's true. Not for a while. Not for a while. What did he say when he left? I shall return?
I shall return.
Yeah, I shall return.
So I have
That's
returned.
what I thought.
Yeah.
Okay. You have returned. Okay, great. So today we're talking about Marbury v. Madison, and of course it's perfect to have Bill, our legal history nerd, on this episode so he can get all legal with this case.
I prefer resident legal scholar.
Resident legal scholar. Whatever you want to put on your business card, Bill, is fine with me. All right, I'm not really worried about it. So Marbury v. Madison, as I mentioned last episode, is a groundbreaking case in American history. There's a good chance that you had heard of Marbury v. Madison. Maybe you know exactly what the case is all about, but the odds are you might not know it in the detail that we're going to go through it today. And whenever I taught U.S. history and U.S. government, my students were consistently surprised at just how big of a deal this case was, and they really loved it. Like when we talk about the story and the people involved and why it worked out the way it did, and they got really into it. So I figured that we could cover it in detail here on the podcast too. So Bill, you ready to go?
Let's rock and roll.
Great. Before we dive into the case itself, though, I want to give a little bit of context and background into the situation. Obviously, last episode, I covered the first couple years of Jefferson's presidency, and I talked about Marbury v. Madison just very briefly, mentioning that we dive more into it today. But at this time in American history, the early 1800s, so this podcast will go from more or less 1801 to the late 1803, 1804. And the foundation of the United States back then and still today was and is the Constitution of the United States. But back 200 plus years ago, in the very early 19th century, at the time of Thomas Jefferson's first term, the challenge was how the Constitution was going to be interpreted, right? And who will be the ones interpreting it. We saw this with the Alien and Sedition Acts, and Thomas Jefferson and James Madison writing the Virginia and Kentucky Revolution, speaking out against them, saying that they were unconstitutional and that the state should have the ultimate authority in determining what they can and can't do. That was our first real big tiff publicly about the interpretation of the Constitution. Well, Marbury v. Madison is the first example of this question, right? Who actually should be interpreting the Constitution being formally considered in the, at this point, very short history of our nation. And the cool thing about this case is it brought these two great Americans at odds with each other, right? Butting heads, cousins and political rivals, face to face, Thomas Jefferson and John Marshall. From Jefferson's perspective, he wanted to let the people speak, let the representatives decide. He believed that each individual branch should have the ability to determine the constitutionality of something within the, roles and responsibilities of their branch. But from Marshall's perspective, as we will find out and talk much more about, and Bill will dive into much more detail about, he believed that it was the court's responsibility to make those interpretations. And he got his chance with Marbury v. Madison to bring the hammer down and make it as official as he possibly could. Bill, I know you wanted to speak briefly about the judicial branch and Article 3 of the Constitution and laying a little more groundwork for this episode.
I do. And I'll start with this question, one of a rhetorical nature, but I'll throw it out there. What is the role of the judicial branch? Now, it's rhetorical today, but in 1800, it was a very serious and still pretty open question. And that's really what we're talking about right now. And it comes to a head, as you alluded to, in the form of Marbury v. Madison. But what is really at stake is the judicial branch's place as a co-equal branch of government. It will become more clear why the stakes were so high as we move into our discussion of the circumstances for why this case came about in the first place. That said, we do need to start where the judicial branch's power emanates, and that is from...
But real quick, Bill, at this point, the Supreme Court, I would always have to go over this with my students, like the Supreme Court, they were literally just judges.
Correct.
They were just guys they were just an appellate court. That's all they were. They just so happened to be the highest appellate court in the United States. And that was it. Like, they were just appellate court judges. They just heard appeals and they made decisions off like just normal court cases.
So you're right, that's
really
because the formality and the structure that we know of the federal court system today was in, I don't even want to say it's infancy. It was what's pre-infancy biologically. That's what it was. It was an idea.
I think they call that a twinkle in the eye, Bill.
That's right. So that's what the federal court system was in the period of time in which we are talking about.
Gotcha. Yeah.
So, but even that being the case, it is still literally one of the three branches of the federal government enshrined in the Constitution. So we have to talk about that. And so that would bring us to Article 3 of the United States Constitution. It is the part of the Constitution that establishes the judicial branch of the United States. In practical terms, it created the Supreme Court, and it also authorized the Congress to create lower or inferior courts. And so we'll unpack each section of Article 3, which, of course, the Constitution, it's probably 15, 20 pages of unpacking, right, Chris? Wrong. Chris, you're wrong. It's Article 3 is three very short sections, which I'll describe briefly right now.
Okay.
The first establishes the Supreme Court and provides the power to Congress to create those necessary lower courts. It also establishes the parameters for how long a judge will serve and under what circumstances a judge could be removed. But of course, we know that today, in the hyper-political nature of federal court appointments going before the United States Senate to be confirmed, because those are lifetime appointments. This is where that comes from. The second section of Article 3 establishes what cases and controversies Article 3 courts can preside over. This is very important. Including its ability to insert itself as the original jurisdiction for some matters, but for appellate jurisdiction for all others. Lastly, Section 2 established that for the trial of all crimes, except for impeachment, there is a guarantee to a jury trial. And last but not least,
well, real quick, Bill, I do want to just sort of take a bit more of a reductionist approach to Section 2 just to make sure everyone understands. So it says that there are some very specific, like a state suing an individual or individual suing a state, which back then you could, when they were writing the Constitution, you could do that. Like that's original jurisdiction, meaning that you can take it straight to the Supreme Court.
And it would operate, and I'll dive into this in a little more detail later. But you're right. Original jurisdiction, essentially, what the Supreme Court would act as in that instance is the trial court. It's what you would see on Law and Order in layman's terms. But there'd be objections and witnesses brought and the parties show up. But that's what we're talking about when we're talking original jurisdiction.
Yeah. But for the most part, most of their jurisdiction is what you would call appellate jurisdiction, which means that it has to go to a lower court first. There has to be a decision, and then that decision has to be appealed up. And for a huge majority of the cases, 95+%, depending on the year, depending on the time, those are the cases the Supreme Court heard and still hears today.
Correct. That's correct. Because the original jurisdiction case types, there are like 4. It's like cases involving ambassadors, essentially foreign governments, dignitaries, and disputes between the states. That's essentially original jurisdiction.
Yeah. So probably like 99% of all the cases the Supreme Court hears and has heard are appellate cases.
I'd have to imagine that's the statistic behind it.
Yeah. Well, I'm very comfortable just arbitrarily making up statistics and sticking with them. So we'll go with 99%.
Respect.
Great. All right. So on to part 3.
So the third and final section of Article 3 discusses treason, and that's it. So those are the 3 sections of Article 3 to the Constitution, which top line, it creates the federal judicial branch and the Supreme Court. But I do have a question for you, Chris, before we leave this topic.
Okay.
Can you please,
I do enjoy the questions you ask me.
I ask tough ones.
Live mic on this podcast.
Some would call them curveballs. Who am I kidding? I'm a straight shooter. Could you please identify for me where in those 3 sections the framers detailed how many justices will sit on the Supreme Court?
Oh, you dog. That's a trick question.
It is.
It does not. It does not say it.
Correct. There is literally no mention in the Constitution for how many justices will preside on the Supreme Court. That was left to the Congress. It, of course.
And that can, just so everyone, that can change too.
Oh,
it can still change.
Sits at 9, but that number has been lower, and as we move forward in history, way higher throughout the course of U.S. history.
Yep.
And I bring that up because it's a pretty solid example of ambiguity built into the structure of Article 3. Conversely, we have the events that precipitated Marbury v. Madison.
Well, and I think that another thing, and I'll sort of get into a bit of the story here in just a second. So basically, for those of you listening, if you're wondering, like, wow, why is the third article so light? Well, a couple of reasons. Number one was practical. These men were exhausted. They were brutally hot in the July, August heat of Philadelphia. They were tired of arguing with each other for months. Many of them weren't even sure that this Constitution would even be ratified by 9 states. And so they for lack of a more legal or politically formal term, they basically punted it. And they were like, all right, well, we will agree to the basic outlines of it, and then we'll just punt the details to the legislature. Whoever the first members of the House of Representatives are that the people choose, they can create the more detailed structure of the judicial branch. And that's what we're dealing with here, because in the Judiciary Act of 1789, that's exactly what Congress did. And that's important to note as we move into this story. So let's sort of set the stage for Marbury v. Madison. It's fall of 1801. Thomas Jefferson is president. And there are 4 men, one of them being Mr. William Marbury, who has been given commissions, verbally told that they are going to be justices of the peace in Washington, D.C. Congress approved them, and John Adams signed for their appointments. Now, they had been nominated for Justices of Peace of D.C. during the midnight appointment phase, the last couple weeks at the end of Adams' term when he was a lame duck president. And he had John Marshall, his Secretary of State, seal them at the same time. Now, the challenge for these men, their commissions had just disappeared in the flurry of activity at the end of Adams' presidency, which seemed to be a bit odd. And they believed that Thomas Jefferson and or James Madison had more or less just ripped them up and thrown them away. So they went to the State Department, which at this time was, of course, now headed up by Thomas Jefferson's Secretary of State, James Madison, to demand their commissions. They said they are legally owed these commissions, and Marbury's very adamant that he wants his commission, right? He wants to become a federal employee, start getting that paycheck, and living that government life. While the men weren't too confident they received their commissions, considering the Federalists had lost the presidency and the legislature, Marbury in particular was determined he was going to do everything he possibly could to get it, whether he thought they were actually going to give it to him or not. When the State Department informed these men that they were actually not going to receive their commissions, and the State Department had no idea what happened to their commissions, they filed a petition to the Supreme Court. They were hoping the courts could force the State Department to hand over their commissions. Now, you may be wondering, why did these men think the Supreme Court had the authority or the power to force the Secretary of State to do really anything? And that goes back to the Judiciary Act of 1789, this law that the House of Representatives created, which filled in much of the missing structure of the judicial branch. Within this law, it included a provision. That provision was called a writ of mandamus or writ of mandamus, depending which syllable you want to put the emphasis on. And what this said, if you like that, Bill? Yeah. What this said was that the Supreme Court had the authority and jurisdiction to hear a case such as Marbury's and to force a government official to comply with his, and now his or her, but back then his, legal obligations. Basically, it said the court could compel someone like, I don't know, the Secretary of State James Madison to follow through with his legal duties, like handing over the commissions to these four men. And so that step sets the stage for the case itself. William Marbury is suing Secretary of State James Madison and demanding that the court issue a writ of mandamus to force Madison to follow through with his actual, duties in the position and give him his commission. And, interestingly enough in all of this, the four men did get their commissions approved initially. It was signed by John Adams, and Thomas Jefferson saw them and pretty much was like, yeah, no, I'm not going to give these out to these four Federalists in D.C. No. And he just trashed them. And so, Jefferson, in this case, to be fair to Marbury and his buddies, Jefferson and Madison were caught red-handed, pretty much just flaunting the law.
I really hope you're all not sick of terms like mandamus and Judiciary Act of 1789, because we got a lot more of that coming up.
Yes, but we're going to try to explain it like we were talking to a 5-year-old, because that's how I always learn this stuff. I would always tell people, just explain it to me like I'm like pure Michael Scott style. Just explain it to me like I'm a 5-year-old.
That reference goes back all the way to Denzel in Philadelphia. Remember that? Yeah. Oh, great courtroom scene with Denzel.
It is.
It's good stuff. Good stuff. All right.
Yes.
But your Michael Scott reference is noted.
Good to know.
The above the fold headline for anyone learning about the Marbury decision is that it established the principle of judicial review. What is judicial review? Again, rhetorical question, Chris. Rhetorical. We will get into the details in a bit, but at a high level, what I'd like you all to consider now is what authority does the Supreme Court have to overturn acts or laws that may potentially run contrary to the U.S. Constitution? The answer is likely an obvious one, but in 1803, it wasn't so straightforward. While it was the Judiciary Act of 1801 that led William Marbury to file a writ of mandamus with the Supreme Court, it was that Judiciary Act of 1789 that was truly at the center of the Marbury v. Madison decision. So we'll pause here because we have two separate Judiciary Acts. One passed in 1801, one passed in 1789. 1789 law gave the Supreme Court the power to hear the type of case Marbury wanted to bring. The Judiciary Act of 1801 actually led Marbury to receive his commission, or attempted commission. That's what we're dealing with these two Judiciary Acts.
Yeah, so the Judiciary Act of 1801 was basically all of the quote-unquote midnight appointments. Yeah.
Let's quickly turn to the quasi-political, but also systems ramifications of what Marshall and the Supreme Court were facing down. They were kind of stuck between a rock and a hard place, so to speak. As Chris talked about earlier, these government institutions were becoming increasingly political. Marshall knew this. Marshall saw two most likely scenario outcomes. The first is that the court fines for Marbury and orders Madison to issue the commissions, but Madison and Jefferson won't comply, and the courts will be rendered pretty much impotent.
Yeah, so the real challenge here was the courts would tell them to do it. Thomas Jefferson and James Madison would, bite their tongues at the courts. And
which was super harsh back then.
Yeah, that's like old school.
Read some Shakespeare.
Yeah. Yeah. And they would refuse to do it, and then the courts would look totally impotent. Like, okay, well, our authority clearly is just non-existent.
Which, by the way, that's not totally out of the realm of possibility. In Marshall's thinking, considering they literally disregarded the law to begin with. So,
yes.
Yeah.
They've already shown that they're willing to disregard the law.
So, that being said, there is a second possibility, and that is the court rules against Marbury. And the byproduct of that is Jefferson and his Democratic Republican allies will have been vindicated. So, Marshall, and
not only that, but it would underscore the idea that you can just flaunt the law and that they're above the law.
Also that.
Yeah.
Also that. Surely there has to be a better way. Marshall likely thought, I'm hoping in his best infomercial voice. And for that better way, we need to examine the legal acrobatics that Marshall executed. With that, let's dive into the legal ramifications from a constitutional law perspective of Marbury v. Madison. I'll pause.
I just real quick, Bill, before we dive into that, I do want to just fill in like a little bit more color to what was going on politically, because, okay, when you think about it, all 6 justices at this time were appointed by Adams or Washington. So, pretty safe to assume they're going to be Federalist-leaning, if not all 6 of them. The majority of them are going to be heavy Federalist-leaning judges, and we know John Marshall was very heavy Federalist-leaning. And the courts were this was a precarious time for them, too. I mean, when you think about it, I covered last episode that Jefferson moved to repeal the Circuit Court Act of 1801. He moved to repeal that act that Adams and the Federalists had passed. On top of that, he was working to get one Federalist judge impeached. A year after this decision, he will actually get a Supreme Court justice impeached. He suspended the term in both June and August, like basically telling the courts not to gather. So it was clear, at least from the perspective of the justices, that they were under attack politically by Jefferson and the Democratic Republicans. Under this harassment by Jefferson and the Republicans, the court recognized that like this case was more than just a commission. It was about much more than that. But like you mentioned, they were really stuck between a rock and a hard place because, they want to take the case because on paper they should take the case because the Secretary of State and or the President are being accused of blatantly violating the law. So the case needs to be taken. but they didn't really know what to do with it. And they recognized what it would look like, that they're a bunch of Federalists hearing a case against the two most powerful men in the Democratic Republican Party. They're the last branch of government that is controlled by the Federalists, and it will be viewed as a political affair, which they didn't want. At this time, they felt like, the judicial branch was under attack, and how are they going to reassert the authority and independence of the judicial branch? And as you'll get more into, in this brilliant decision by Marshall, he was able to avoid option 1 and option 2 and reassert the independence and authority of the judicial branch. But I think that that's like laying that political backdrop is important when considering what their very real practical challenges were when taking this case.
Surely there has to be a better way. I am pretty confident that's what he thought to himself.
Yes. Yeah, something along the lines of, "Oh, geez, do we really have to do this? Can we just pretend like we never received this petition?"
Thank you, Chris, for that eloquent summation of the political dynamics at the time. Well stated.
You're very welcome. Thank you.
Back to the case, though. In my opinion, the primary question at the center of this case is whether or not Marbury should receive his judicial commission. And if so, does the Supreme Court, aka the judicial branch, have the authority to order the executive branch to deliver those judicial commissions? Let's start by unpacking the various aspects of those questions. First, how would the judicial branch compel a member of the executive branch to issue the judicial commission? It is through the very instrument that Marbury filed suit for. We're back to the writ of mandamus. Essentially, it is an order from a court to an inferior government official, ordering that government official to properly fulfill their official duties or correct an abuse of discretion. I think we could fairly state this fits the bill for what Mr. Madison was doing at the time. Chief Justice Marshall must figure out if the writ of mandamus is the proper vehicle for a remedy to the harm done to Marbury. In Marshall's estimation, the writ of mandamus is the appropriate remedy. The next question is whether or not that writ could be applied to the executive branch. Marshall answers that question in the affirmative, as not even the president is above the law and could be subject to a writ of mandamus.
So early on, it's looking pretty good for Marbury.
It is. The last piece, though, of Marshall's calculus is whether or not the Supreme Court has jurisdiction over the case, which really, in today's world, that is actually the first question that is often asked. Has this properly been filed? Remember, Marbury took his case directly to the Supreme Court because he believes that this is an example of where the Supreme Court has original jurisdiction over this case or controversy. That is to say, a case where the Supreme Court would act as the trial court, not subsequently being heard on appeal, like Chris and I were talking about earlier.
Yeah. And it also makes sense. I mean, he lived in D.C. They're in D.C. They're a group of 6 likely Federalists. I would go to them first, too.
And the Judiciary Act of 1789
said that he could.
It.
Yep.
Today, my estimation is that most understand the Supreme Court as the place where previously decided cases go when they are appealed. Usually, you don't go directly to the Supreme Court. And as Chris said in his rock-hard statistic, 99% of cases of the Supreme Court hears are appeals. Yeah.
And actually, and I also will be making up a statistic, but I know it's insanely high. An extremely high percentage of appeals to the Supreme Court aren't heard.
Oh, correct. Absolutely.
Like 90, like another percentage like in the high 90s.
So
like 90,
I don't remember the
98%
numbers off the top of my head, but as you continue going up the ladder, the appeals ladder, the likelihood of you being granted an appeal becomes far smaller at each level, infinitesimally smaller, if that's a word. And obviously, when the Supreme Court is at the last stop on the highway, you can imagine how much of a long shot. Getting them to.
Yeah, I just a quick Google search. 10 years ago, the success rate was 2.8%.
Yeah.
So we're talking like 90, 97, 98% of them are turned down.
Yeah. In the Marbury case, what ends up happening, though, is that Marshall determines that this particular case does not qualify to be in the Supreme Court's original jurisdiction. There are a list of cases in Article 3. We talked about this a little bit, but Article 3 enumerates what cases can be heard by the Supreme Court in its original jurisdiction, those being cases affecting ambassadors, other public ministers, and consuls, and to cases in which the states shall be a party. Basically, those cases involving foreign countries and states. It's less likely Marbury fits into that, and his three other plaintiffs. That list did not include cases like the one William Marbury filed. Now, I know what you're likely thinking. Okay, Bill, well, the Constitution spells out what original jurisdiction the cases that the Supreme Court can hear, but we also gave Congress some ability to set up inferior courts. We deferred to Congress on a lot of stuff, and they said in 1789 that the Supreme Court can hear that type of case in the Judiciary Act of 89. Well, let's put a pin in that because the analysis does not end there. The additional complication at the core of the case is Section 13 of the Judiciary Act of 1789. This piece of legislation passed by Congress told the Supreme Court it could hear cases like Marbury's and issue those writs of mandamus to public officials. You may be thinking, okay, Bill, I've heard a lot now, and this seems to be a pretty open and shut case. Article 3 defers certain powers to Congress of the judicial branch, and this was a fully enacted statute. So why did Marshall still say Marbury should not have brought his case before the Supreme Court? And that, my friends, brings us to the doctrine of judicial review.
So to sum it up real quick, the questions that the Supreme Court were considering. Number one, did Marbury have a right to the commission? They said pretty much unanimously yes. Number two, if he does have a right, and if his right has been violated, is he legally due that commission? Answer being yes. Number three, if he's legally due his commission, what can the Supreme Court do about it? Can the Supreme Court do anything about it? And on paper, as you're alluding to, it would be a yes. And there were some justices who were arguing pretty vehemently that, yeah, we can use the writ of mandamus to compel Madison to give the commission. Of course, the catch with that is Madison and Jefferson could just ignore it. So how did Marshall sort of navigate around these what seemed to be obvious resolutions? That
is the question that rules the day. Marshall says that this federal statute, Judiciary Act of 1789, in particular, Section 13, conflicts with what is contained within the Constitution. And when you have a conflict between the Constitution and a law, the Constitution wins. The central idea Marshall posited was the judicial branch has the right to review the laws to ensure they comply with the Constitution. If the law is found to not comply with the Constitution, thereby being unconstitutional, the Supreme Court is unable to enforce that law. In the end, Marbury lost because the Supreme Court didn't have jurisdiction because the law that stated they did have jurisdiction was found to be unconstitutional. And
gotcha. So real quick, Article 3 of the Constitution, which outlines the basic bones of the judicial branch. Section 2 outlined this is where you have original jurisdiction, this is where you do not. And it has to go to a lower court first. Judiciary Act of 1789, the Section 13, when it talked about writ of mandamus, it didn't come out and say it. And this was interesting. Marshall interpreted
yes,
it
that's important
as
to note.
saying,
Yes,
and that's
it's an
very important because
interpretation,
I have no doubt there were justices. They were arguing with him like, you don't have to interpret it this way. And he's like, but this is how I choose to interpret it because like I have this trick up my sleeve. He interpreted that this section gave original jurisdiction to a guy like Marbury, correct?
Yes.
By giving a guy like Marbury original jurisdiction, that flew in the face of Article 3, Section 2, which detailed exactly when the Supreme Court would have original jurisdiction. So basically Marshall's saying, well, if I interpret it this way, which is a fair way to interpret it, then that means that Congress is trying to expand the jurisdiction, the original jurisdiction of the Supreme Court. And one branch of government cannot just like fundamentally alter the makeup of another branch of government.
Right.
That's unconstitutional unless they want to amend the Constitution.
There is a process should they want to amend the Constitution, the amendment process.
So that is the part that he found to be unconstitutional.
Correct.
The fact that this Section 13 of the Judiciary Act of 1789, which was passed by one branch of government, is telling another branch of government that it's going to have a different makeup. And by passing a law, you can't do that. You would have to go through the actual amendment process to do that.
And to sum it up, to sum Marshall's thoughts up, this also happens to be, in my estimation, the most famous line from the opinion. Marshall writes, it is emphatically the province and duty of the judicial department to say what the law is. This is the very essence of judicial duty. So that's pretty cool, right, Chris? That the court, that's the court's role to call balls and strikes, so to speak. Surely you can point me. Oh, this is question number 2, Chris, by the way. I got another one for you.
Oh, I have another one. Okay. Coming in hot.
Now, Marshall, if you follow his logic, it's pretty sound, right? So clearly this is underpinned by something. So that's something probably being the Constitution. So can you point me to the section in Article 3 that addresses the court's power of judicial review?
That is another trick question because judicial review is not in the Constitution.
2 for 2, Chris.
Nice.
Batting 1,000.
Right. Good.
You'd be a Hall of Famer.
Good. I know.
It's not in the Constitution. You alluded to it, didn't come out right and say it while we were talking about the case itself. It was a legal extrapolation by Marshall. The Supreme Court used its own understanding of the Constitution in reviewing the legitimacy of acts by the other branches of government, even though this power is not apparent from the plain text of the Constitution. Now, there is, of course, Article 6 of the Constitution, the Supremacy Clause. Surely judicial review, the spirit of judicial review lives in the Supremacy Clause, but it does not specifically refer to judicial review as an enumerated power of Article 3 courts. Alexander Hamilton wrote of judicial review in Federalist 78, but somehow this power did not make its way into the Constitution. And honestly, I think it's what you were it's the reason why is what you were talking about earlier, Chris. They punted on a ton. And I mean, this one seems to be a pretty glaring omission, but they did. They punted on a ton of stuff. So here we are. Another way of putting it, though, it was a judicial power grab. And perhaps a legitimate one, but a power grab nonetheless. Not to miss out on an opportunity to point out a great piece of irony, though, to me anyway. The Marshall Court essentially struck down a law for claiming it was inconsistent with the powers granted to the Supreme Court in the Constitution by inventing a power not explicitly in the Constitution. I found great irony and delight in that. Yes.
So when we talk about judicial review, and I know you've mentioned it, explained it earlier in the podcast, but just to reinforce it, it is the power of the Supreme Court to decide if two laws conflict with each other, or if a law conflicts with the Constitution or the court's interpretation of the Constitution, then the court will decide whether or not that law is constitutional or not. And for the most part, like almost all of the cases the Supreme Court hears today are questions of judicial review. Especially the most groundbreaking and most polarizing cases are questions of judicial review, which is like, that's the incredible thing. I mean, when you think about it, all of these groundbreaking court cases, the only reason why they're groundbreaking Supreme Court cases is because the Supreme Court gave itself the power to be the final arbiter on whether or not something was constitutional, which, like you mentioned, is not actually in Article 3 of the Constitution because the founding fathers were really tired and hot and wanted to go home.
I want to talk a little bit more about that.
Sure.
And Michael Klarman, a legal historian and professor of law at Harvard, writes that there really wasn't much discussion amongst the framers at the Constitutional Convention about the concept or power of judicial review. Klarman claims that there were more delegates in favor, though, of the concept of judicial review than who opposed it. Kevin Walsh, professor of law at Richmond, says that while it was a sizable power grab of a truly awesome power, there is very little dissent when it comes to whether the Supreme Court should actually have that power at all. Are there arguments over how judicial review should be exercised? Certainly. But what is not in dispute is the Supreme Court's ability to declare a law or act unconstitutional. That appears to have been settled by John Marshall in 1803. To put a little bow on it, at the end of Marbury v. Madison here, the decision.
Bill always, you have to tie at least one bow each episode.
I do. I'm a bow tire.
You are.
The decision was unanimous, 4-0. But you might be saying, Bill, I know there were 6 justices back then, not 9.
Yeah, I'm doing hold on, 1, 2. Yeah. No, yeah, we're missing 2.
2 recused. So 4-0. And unfortunately for Marbury, the result was that he was denied his judicial commission.
Yeah, so I want to go over just like the 3 basic points of the decision, right? And just make it really clear for people. So the decision said, number 1, sorry, Marbury, we understand why you're upset and we understand why you think you deserve the commission, but we don't actually have jurisdiction to hear this case. You should have never come to us. We probably shouldn't have even taken the case in the first place. So I'm sorry, but we can't even rule on what the petition that you filed. But moving on to the second point, while we're sitting up here and giving a decision that will have the force of law, we'll just keep talking. And they said, point number 2, the Judiciary Act of 1789 gave the court the power that the Constitution itself does not give it. That power is to be able to use the writ of mandamus in cases that originate in the Supreme Court, which would fall outside the original jurisdiction. Therefore, Section 13 of the Judiciary Act of 1789 is unconstitutional. And that leads us to the third, more or less, and you said the quote from Marshall there where he really strongly alluded to it, but the somewhat unsaid aspect of this, which is the concept of judicial review being applied to the federal government. So part number 1 is, sorry, Marbury, you didn't actually have jurisdiction. Part number 2 is the piece of legislation that gave you the jurisdiction is actually unconstitutional. Part number 3, the fact that we just said it was unconstitutional, we are now exerting our authority to interpret the Constitution and determine whether or not a law is constitutional. So by saying that the Judiciary Act of 1789 is unconstitutional, they are more or less acting out. They are actually doing judicial review, which of course then sets the precedent that the Supreme Court has the power to do judicial review at the federal level.
Again, Chris, eloquently stated and recapped.
Thank you. Thank you.
You're on a roll this episode.
I mean, did all that make sense? Everything I just said?
I want to take a moment. Well, yeah, obviously. When Zach's on, you're not so eloquent. When I'm on, you bring your A game. But I rise to the occasion. Yeah, I want to hammer the point home, though. I want to hammer the point about judicial review home and how big a deal this was. And I know will come. You sort of alluded to that fact, as most cases the Supreme Court hears are on this very question. But we'll touch on these going forward. But when you start thinking about how judicial reviews played a role in American history, think about these examples. The court instituted judicial review when it ruled against Harry Truman's seizure of steel mills. The court instituted judicial review when it overturned Trump's initial travel ban. It also exercised judicial review when it upheld the bulk of the Affordable Care Act. But that wasn't always the case. The Supreme Court did not institute judicial review invalidating a federal statute for another 50 years after Marbury. And that was when the court utilized judicial review to invalidate
Dred Scott?
The Missouri Compromise in the notable Dred Scott case.
Yeah.
So the legacy of John Marshall's power grab impacts every part of our lives as citizens of the country. And
100%.
And this is one of those times where we're not overstating that. I mean, it's like this power that he, didn't pull out of thin air. It existed within academia and the framework and the spirit of the Constitution, but it wasn't written in there. Marshall created this.
Yeah, and it really created, because look, it's the writing of the original Constitution, depending on how you interpret it, of course, the legislative branch was by far the most powerful. That's how Madison wanted it. During Washington and Adams' presidencies, they increased the power of the executive branch to begin to rival that of the legislative branch, and that's why the Democratic-Republican Party was formed in the first place, because they thought that the executive was becoming too powerful, and this looked too much like a monarchy, and this is not what we intended. The whole time, they expected the judicial branch to just be, a bunch of courts. Appellate courts, right? Trial courts and appellate courts, and that's about it. And the executive and legislative branch, specifically the legislative branch, are going to be the ones doing the governing and running the government. But this very much creates an almost three equal branches of government. You mentioned most recently with the Affordable Care Act that, the decision, that is judicial review, and the Supreme Court decided. Look at Bush v. Gore. Right? The case with the Japanese internment. Like, all of this stuff is judicial review. All of the most, Roe v. Wade, all of the most consequential things the Supreme Court has ever done is off judicial review. And that makes it a much more equal branch of government in the short and long term. But you mentioned that they don't use it again for another 50 years. And one of the reasons why some historians speculate is because about a year after this decision, Samuel Chase, who was an associate justice on the Supreme Court, was impeached. And he was one vote away from being removed from office for being basically too much of a rabble-rouser for Jefferson and the Republicans. And that was a sort of a shot across the bow at John Marshall. That, like, if you use judicial review to do something extremely controversial and not within the spirit of the newly Republican electorate, we're going to impeach you and just remove you from office and just be done with it. So I think that was probably one of the reasons why it happened that way. So, Bill, anything else to add, or you think we've effectively tied the bow on Marbury v. Madison today?
I think I've waxed poetic for long enough for this episode.
Of course.
We can't overstate Marbury, but we can overstay our welcome, I guess, with the listeners.
Yes,
so
that's very true.
That's
very true. All right. As you pack up your things, I'd like you to consider just how many monumental things were happening during Thomas Jefferson's presidency. I mentioned, and I may have beaten a dead horse with it last episode, about how big of a deal the transition of power from the Federalists to the Democratic Republicans were in the election of 1800. And don't worry, I'm not going to go on yapping about that any longer. I think you've gotten the point. But when you include things like Marbury v. Madison and the impact that this case had, along with the foreign policy issues that Jefferson faced, something we'll talk about next week with the Louisiana Purchase, doubling the size of the United States of America, the trip of Meriwether Lewis and William Clark. There's a lot going on in Jefferson's presidency and stuff that we will get more into in episode 94 and beyond. But always remember that Marbury v. Madison was the case that totally changed the makeup of the equality of the three branches of our government. and Thomas Jefferson's decision not to deliver those 4 commissions to justices of the peace in Washington, D.C., that what seemed like such an inconsequential decision out of basically resentment and spite totally changed the makeup of our nation and impacted the lives of every single American who has lived since then. Next week, like I mentioned, we'll continue with Jefferson's presidency, and we'll dive deeper into the most famous decision Jefferson made, and that was the one to begrudgingly, somewhat, purchase Louisiana. Thanks for listening, and hopefully now you can take pride in knowing just a little bit more about the history of the United States. Class dismissed.